Hi everyone, my name is Pouya Azimi and I'm here joined by Priscilla and we both work at Lab & Partners in the GDPR team. Today we're going over some of your basic questions, frequently asked questions, as well as cover some of the definitions in GDPR.
What is the right to erasure?
The right to erasure covers what you call the right to be forgotten under the GDPR. What that means is that a potential data subject can come to you to ask that their data be erased completely. So what that will mean for a controller is that not only do you erase the data, but you also inform every third party to whom you've given the data to also make sure that they've erased it. So potentially that's within the rights of an individual.
But what if there's another regulation that contradicts this and you have to keep some type of information, whether the data subjects wants it erased or not?
Yeah, that's a very good question, Priya, about if for any regulatory reasons you need to keep a data longer than it should be kept for. Now the GDPR allows you to keep that. The only thing you have to bear in mind is that you have to let the individual know the reason why you have to keep their data for even longer and make them understand that it's a regulatory requirement for you to be able to do that. Apart from that, the second thing to also know as a controller is to make sure that you have got the right safeguards to be able to keep that data safe for that individual.
Are controllers and processors required to obtain consent for existing relationships?
The quick answer to that, to me, Priya, will be a general no. Really, you don't need to. However, consent is one of those topics that you cannot really discuss in a 1 minute block to be able to say whether or not you should be able to collect consent. I believe that in terms of consent, you're meant to look at every case on an individual basis. If you already have an existing client and you have a legitimate reason why you're doing business with them, you don't necessarily need to go back to them again to get consent. But however, if you go through that inventory of personal data and you realize that there's some missing gaps and you might need consent, then yes, I would advise that you go back, even if they are existing clients, and then take consent from them. But then again, back to the question, the answer really is no. If they're your existing clients, answer to that is that you already have a relationship with them, which is one of the key things in GDPR. That relationship that you have with them means that they would expect some sort of communication from you. And if they expect that from you, then it's reasonable within their rights. Priya?
I guess, yeah, the principle that we really have to pay attention to would be the fair use of information, and you should always make sure you have a legal basis for processing.
Definitely, I agree.
What is the ICO and what is its role?
With regards to GDPR, every country in the EU has its own supervisory authority. In UK, the ICO, or in Information Commissioner's Office, it's the prime authority with respect to GDPR. They have the power to prosecute, impose fines, and suspend trading activity if applicable.
What is a data subject under the GDPR?
The GDPR defines data subjects as any natural person who live within the EU countries.
What is personal sensitive data under the GDPR?
GDPR divides data in two different categories, sensitive and non-sensitive. Example of sensitive data based on Article 9 of GDPR would be political affiliations, religious beliefs, and ethnicity.
What are the rules for data collected via the exchange of business cards? Can we store this data?
Absolutely, you're allowed to store any data that you deem fit. The rules guiding data storage are around making sure that the real reason why you collected that data, there is a legal reason for that processing. So as long as you can identify a legal reason for processing that data, as long as you can securely store that data, as long as you've got the consent, if consent is required from the individual while you're storing their data and they've agreed to it, you're more than, it's more than you can store data even if you've received it from a business card.
Do data policies need to be specific to an organisation, or are there generic policies?
GDPR policies, as in May, there's some of them that are generic, but I would say that in terms of solutionalizing policies for organizations, I will probably look at making sure that it's fit for purpose for that particular organization. So yes, you will have some generic ones like the data erasure policy. There will be ones on individual rights, which is around the scopes of GDPR. However, depending on the different organizations, you might find that you have more needs or lesser policies. So everything is all about doing a full risk impact assessment, finding out what you've got and finding out what you need to be able to be GDPR compliant. So the answer to that really is a variation of a yes and no. you might find that there are some generic ones that you'll need, but you'd also find that there are some specific ones to your company depending on the kind of clients that that you'll find useful.
Do you have to look at every client account individually?
No, you don't have to do that. Absolutely not. So in terms of when we talk about GDPR, we're not talking about accounts per se. We're talking about personal data. So when you're looking at that, you're looking at how the flow of information works within the organization. So rather than looking at that individual accounts, you're looking at the personal data. GDPR is about protecting the personal data of the European individuals. So your job as an organization is to look at how data will travel or how that personal information travels around the system. So protecting it as a whole, as opposed to individual account assessment, is what I would say.
Is where you store your data relevant?
Yes, where you store your data is absolutely relevant. So when you're looking at storage of data, you're looking at processing of data. So processing comes on the storage. So in order for you to be GDPR compliant, part of what we look at is where you store your data. Is your data stored within an EU member state, or is it stored outside the EEA? Those are the things that we look at. Again, we want to make sure that where you're storing that data, ideally, GDPR says it has to be within the EU member states.
If data is collected from research of publicly available information, does this fall into the scope of GDPR?
Yes, so data protection covers anything that comes within the remit of data. However, when you talk about public research, I believe under Article 89 makes reference to when you're storing data based on public research, that could serve as an exception to the general rule when it comes to data erasure. Now, what you need to be thinking at that point is, even if you're allowed, yes, you are allowed to store data slightly longer if you can prove that obviously you want to use it for public research, etc. But one of the things that you have to bear in mind is that the ICO talks about the safeguards that have to be in place. So you have to have the right amount of safeguards in place, again, to protect the individual rights. So you have to be thinking about how you're protecting that person's data. So things around data anonymization could come in at that point where people's data are no longer attributed to them, but you can still use that data to do your research and still get the right results.
Should we expect any implications of GDPR in relation to Brexit?
Yeah, so Brexit is a big worry in people's minds right now as to obviously when we do come out of the EEA, how do we go from here? But one of the things that there's been so many speeches. I mean, there was one from the Prime Minister, there's one from the ICO, and basically what will happen is that because we're already GDPR compliant, the chances are that we're going to be recognized as an adequate country anyway. So what that means is that whatever we've got planned or whatever we have put together as a result of GDPR going forward will still be applicable, and that will mean that the ICO and the supervisory authorities will recognize us as an adequate country, and that will mean that we can carry on trading information even going forward.
What are data controllers and processors expected to do in order to demonstrate transparency?
The biggest thing to do to demonstrate transparency is your privacy notice. I don't know if you might have noticed, but a lot of companies now are starting to bring up a new privacy notice. And what that means is that we are updating privacy notice to make sure that our information is as transparent as possible. So before an individual or a client onboards, the job of the controller is to make sure, the processor is to make sure that you've got an adequate privacy notice that can be transparent enough for them to understand why their information is being collected, who is going to be using their information, where it's going to be passed on to, third parties, is it going to be within the EEA, is it going to be transferred out? So it's all about transparency, and the best way you can be transparent is to make sure that you've got an adequate and a sufficient privacy data notice that can help you achieve that.
If you have any questions about the topics raised in this video or need any help with GDPR, please get in touch with us. Our contact details are on your screen now.